Okay, I think we will resume our second half of today's event. So you can, of course, continue to sit towards the back of the room, but you're also welcome to come on up to the front of the room, wherever it's convenient. My name is Sean Murphy. I'm the Manat Professor of International Law here at George Washington University, where I teach international law and foreign relations law. It's really a great pleasure to be moderating this panel. We've got three fantastic practitioners in the field of international law with direct experience relating to Ukraine. And so I think we're going to benefit greatly from their remarks today. Let me begin by introducing our panelists. To my right, to your left, is Marney Cheek. She's a partner at Covington Burling. And at Covington, she co-chairs the International Arbitration and Disputes practice and advises companies, NGOs, and governments on high-stakes international disputes and legal strategy. She currently represents Ukraine before the International Court of Justice. To my left is Yuri Parkhomenko. He's a partner at the International Litigation and Arbitration Group of Foley Hoag, based up in Boston. He advises states on international law and represents them before the International Court of Justice and other leading international dispute resolution fora. Yuri currently represents Ukraine in arbitration cases. And then all the way over on my far left is Ena Dion. She's the Senior Program Officer for Police Reform at the U.S. Institute of Peace. Her work explores how internal security actors in conflict and post-conflict environments confront criminality, violence, and extremism and contribute to stability and the rule of law. Most recently, she's been overseeing a project considering how the war has impacted the security and justice sectors in Ukraine, connecting local justice and security dialogue processes to national policing reforms. So we're still getting a little bit of feedback from our microphone. We'll see if we can rectify that. But in the meantime, I will just speak very loudly and say that we've designed the panel to be a bit of a question and answer format. So instead of having set piece presentations by each of the panelists, I'll put to them a question and they'll respond, and we'll see if we have a bit of back and forth on it as we move forward. Okay, so to start, I'm going to turn to you, Marney. Just 2 days after Russia's February 2022 intervention in Ukraine, No, it's okay. Mr. Parkhomenko says it's like in the movie Dune. Maybe it has a worm-like sound to it or something, I don't know. Okay, so my question to Marney is, just a couple days after the Russian invasion in 2022, Ukraine launched a case at the International Court of Justice against Russia, claiming that Russia's assertion that its invasion was necessary because Ukraine was committing genocide in eastern Ukraine, and that Ukraine's position was that Russia's claim that Ukraine was committing genocide was itself a violation of the Convention Against Genocide. In March 2022, the court issued an order on provisional measures of protection, which said that Russia shall immediately suspend its military operations in Ukraine, but that order seemingly fell short of ordering that Russia withdraw from Ukraine. Earlier this month, maybe not known to all of you, but on February 2nd, the court issued its judgment on jurisdiction in that case. And in that instance, the court found that it only had jurisdiction related to Russia's allegation of genocide by Ukraine, and not jurisdiction over whether Russia itself was committing genocide in Ukraine. So the basic question to you, Marney, is these rulings seem limited in nature, In your view, is this case advancing accountability and justice?
Thank you, John, and thank you everyone for being here today. I do think that this case that Ukraine brought is advancing accountability and justice, and for a couple of reasons. I think I'll start with a recent jurisdictional decision, and then I'll go back to the provisional measures order that you referenced. So Ukraine did bring this very unique case to the International Court of Justice. It wasn't the typical case where they said Russia's committing genocide in Ukraine. This was just 2 days after Russia's invasion. To build a genocide case involves a lot of evidence, etc. And that's not really kind of where things were at the time. But Russia had been accusing Ukraine of committing genocide against its own citizens in the Donbass region in the east, actually since 2014. And if you looked at Putin's statements, why Putin said he was invading Ukraine, he said he was doing it because Ukraine was supposedly committing genocide in eastern parts of Ukraine. And so Ukraine brought a very unique case to the International Court of Justice. They said, in the first instance, Russia's allegations are false. We've been falsely accused of genocide. We have not committed genocide against our own people, and that's a lie. And then the second part of Ukraine's case said, and Russia relied on those false allegations to justify their invasion of Ukraine. And by relying on a false accusation of a violation of the Genocide Convention, Russia abused the Genocide Convention. And if you think about it, all treaties are supposed to be performed in good faith. Obligations are there to be adhered to and not to be abused. And so this seemed like a classic case where Russia was twisting its obligations and really abusing its obligations under the Genocide Convention under this false pretense of genocide to invade Ukraine. So that's the novel case that Ukraine brought before the court. And what the court found on jurisdiction was that Russia's false allegations of genocide comfortably fit within the Genocide Convention, and they felt that they could assert jurisdiction over that claim. And what they found with regards to the assertion that the reliance on those false allegations of genocide as a justification for invasion also fell under the Genocide Convention in their jurisdiction as an abuse of the treaty. There, ultimately, the court decided that was a separate aspect of the dispute, really that resonated more within the use of force rather than the Genocide Convention. And so they declined jurisdiction over that piece of it. The part of the case also that hasn't really been talked about a lot, those are kind of the two aspects, is that there is a provisional measures order, as you mentioned in that case, and that provisional measures order remains in place because the case is going to the merits. And that's quite significant, I think, for a reason that I'll describe in a moment. Is this case advancing accountability and justice? I would say yes, for many reasons. One, 32 state parties also intervened in this case, encouraging the court to actually assert jurisdiction over both aspects of the case. In fact, it's quite interesting that having so many states parties provide their views of the treaty, that the court actually didn't adopt that approach that was being advocated by the parties that had intervened. But I do think it sent an important message to the Russian Federation that there's a very much a united view that Russia is violating international law. And at this jurisdictional phase, Russia's objective, of course, was to knock out the case entirely. Like they did in Georgia v. Russia many years ago, they were able to get the case dismissed on jurisdictional grounds, and so they're never held to account. So I think it's actually a very bad outcome for Russia, but a good outcome for accountability, that this case will now move forward to the merits. In the first instance, it will focus on kind of Russia's lie, that is the whole premise for their invasion, this idea that there was a genocide in eastern Ukraine. And in the second instance, it will focus on Russia's violation of the Provisional Measures Order. So as you noted, really very short, the International Court of Justice is not known to be the body that moves the most quickly when it comes to courts, but really within just a couple of weeks of the full-scale invasion at the end of February, on March 16th, 2022, the International Court of Justice issued this Provisional Measures Order. They ordered Russia to cease its military operations in Ukraine, and that for any group that Russia controls, that it also should ensure that those groups not take any steps in furtherance of the military operations in Ukraine. That was a very strong order. It was a very clear order. The court has not issued such a strong and clear order since. In the recent South Africa-Israel case, South Africa sought that same order, but the court didn't grant it. And so that, and Russia's clearly in violation of that order since March 16, 2022. And so when it gets to the merits, there will be a focus on the fact that each and every day that Russia's been in violation of that Provisional Measures Order, which is a separate violation of international law, they've been in violation of international law, and so reparations will be due. And so I actually think the case moving forward will be quite significant, particularly on accountability for all that the destruction that's happened in Ukraine since that Provisional Measures Order was handed down.
Great, that's very interesting, and we're going to come back to talking further about ICJ and Russia, Ukraine v. Russia, but I want to turn to Yuri next. Leaving aside temporarily the state-to-state scenario, we can of course talk further about it later. Let's switch over to the criminal side of things. Talked about a little bit in the first session with Ambassador Taylor. Russia is not a party to the Rome Statute, but Ukraine has accepted the ICC's jurisdiction over war crimes, crimes against humanity, and genocide committed in Ukraine since 2014. In the wake of Russia's 2022 invasion, there was much discussion about criminal accountability for Russia before the International Criminal Court. But to date, the ICC has only issued arrest warrants against Russia's president, Vladimir Putin, and Russia's Presidential Commissioner for Children's Rights, Maria Lvova-Belova, for unlawful deportation and transfer of children from occupied areas of Ukraine to the Russian Federation. A very important issue, but somewhat limited when one thinks about the allegations of much broader kinds of criminal acts. Moreover, in this instance, the ICC has no jurisdiction to address the crime of aggression. So in your view, similar to the question I asked to Marney, is the ICC capable of advancing accountability and justice in this context?
Well, it can, it is capable, provided it has consent, provided it has jurisdiction. And as you mentioned, Russia is not a party to the convention. Yes, we have 123 states, parties to the convention, which have the obligation to take Putin and expedite to the court's jurisdiction. But the question whether it will happen is yet to be seen in the future. However, I think that if we take this development, it is a first step, in my mind, on a long road to accountability. The road will be long, but it is important to make this step. And I think that the ICC made a very creative and impactful step by not issuing an arrest warrant covering all matters in which Putin can be indicted, all those atrocities that has been committed by Russia in Ukraine under his command, but concentrated on a very limited issue, the deportation of children. And this is the, just want to make sure that many of you know that in the course of the Russian war of aggression, Russia has taken serious efforts to remove from the Russian territory Ukrainian children to Russia. And then Putin adopted a presidential decree which expedited the adoption of these children. So many of these children end up in some Russian families, some were very far away in Siberia. Other children end up to be in so-called re-education camps, where Russia is indoctrinating into their minds hatred towards Ukraine and apparently is preparing them to be combatants in future conflicts that Russia wants to wage. So I think that the ICC made a very smart and clever move by concentrating on this aspect of many criminal violations by Russia, because children elicit sympathy from everyone. This is really uncontested issue. Moreover, this issue will not raise any doubts in the minds of people, because Putin himself wrote and signed those presidential decrees, and Putin himself met with his counterpart, the woman with that long name, who was praising in front of Russian propaganda. It is so happy now for me to feel that what it takes to be a mother of a child from Donbass, right? So there is a clear admission against interest, clear evidence that you can act upon. And I think that it is really important that the court really took this low-hanging fruit and really tried to exploit it to galvanize, in the first instance, the public opinion across the world. And the impact of this decision was really immediate, because we saw the reactions of many states when they said, we would not accept Putin, or if Putin comes, we will extradite Putin. And you probably also saw a very interesting development in South Africa, right, where Putin was about to come to a BRICS summit, right, in South Africa. Ultimately, there was a diplomatic issue there between the two countries, and ultimately it was mutually agreed between Russia and South Africa that instead of Putin, Lavrov will come. So what does it mean? Yes, Putin is not, we're not able to put handcuffs on his hands right now, but we significantly limited his potential impact, his potential travel across the globe. And who knows, and the situation on the battlefield will evolve in such a way that we might be in the situation where we could not imagine before with respect to Slobodan Milosevic, right? At the end of the Yugoslavian war, ultimately he was apprehended and he stood trial before the Yugoslav crimes, former Yugoslavian crimes tribunal. Yes, he did not live the day to see the justice. He died of heart attack. But at least people saw the element of their vindication, the element of justice, that a person ultimately stood trial. So I think the bottom line is that, yes, it promotes accountability, but this is just a first step in the long, long road. And I'm sure that if all of us combine our efforts together in all the capitals, I think this road will be shorter than we think.
Thank you for that. It is striking that when the ICC indicted Vladimir Putin and his commissioner for children's issues, the attitude within the United States, within the U.S. government towards the ICC turned around very quickly, with many senators who had previously opposed any U.S. support for the ICC suddenly saying this was something worth doing, passing new laws, providing new kinds of support. So it really had an effect, certainly within the United States as well. Let's talk about maybe broader legal tactics here. I'll go back to Marney. We're holding Ena in reserve until we get to the post-conflict issues. But back to you, Marney. After that Russian intervention in 2014, you helped Ukraine bring a different case against Russia, this time under the Convention on the Elimination of Racial Discrimination and the International Convention for the Suppression of Financing of Terrorism. There too, just earlier this year, we have a judgment on the merits. It was rendered on January 31st, and the court found in favor of Ukraine on a number of issues, but did not address what at least outsiders might view as the core issues about the legality of Russia's annexation of Crimea. So feel free to address the specifics of that case as you wish, but I'm also interested in your broader reflections on whether we can really count on international courts and tribunals that possess pretty limited jurisdiction when it comes down to it, forcing you into particular treaties that may not be obvious fits. Again, for trying to achieve justice and accountability in a situation like this.
Yeah. Well, no, I think you really touch on something important, which is to be before the International Court of Justice, you need the consent of both parties, and that consent, if a country hasn't submitted to the universal jurisdiction of the court, is going to be in a treaty. And so I'm sure Ukraine would have loved to bring a case before the International Court of Justice focused on the very specific question that the occupation and annexation of Crimea was unlawful. But that was not an option to bring that case before the International Court of Justice. And therefore, the question is, do you sit back and do nothing because the most obvious tool is unavailable? Or do you try to think of other tools you can use to at least introduce some accountability and justice into the process? And I'm of the view that Russia cares about international law. Like if you look at international legal institutions, at the ILC, at the International Court of Justice, actually, in the Registrar's Office, in various institutions of the United Nations, there are a lot of Russian international lawyers there. And indeed, Russia cloaks its unlawful activity in the language of international law. Like, take the invasion. They could have just invaded Ukraine for the reasons that most of us know are behind the invasion, which is just they want to capture Ukraine and make it Russian again. But instead, they said, oh, well, we must invade because we are going to protect the people of Ukraine against an unlawful genocide in violation of the Genocide Convention, right? So I do think that if they're going to twist and abuse international law as they violate international law, someone should stand up and say, like, there are limits. There are limits on your behavior. And there are limits on your behavior in some treaties that you've actually signed. Like you can't just pick and choose when you think you want to adhere to your obligations under international law. And so, Ukraine looked at these two treaties, the Terrorism Financing Convention and the Convention for the Elimination of All Forms of Race Discrimination, the CERD, and said these treaties do fit some of Russia's unlawful behavior. The CERD case focused on racial discrimination against ethnic Ukrainians and Crimean Tatars in Crimea, and the Convention for the Suppression of Terrorism Financing case focused on Russia's supply of money and weapons to DPR and LPR, which were then used to commit terrorist acts on Ukrainian civilians in the east. So I think my good colleague Harold Coe has a turn of phrase, which I also like, which is that Russia's short game is force and Ukraine's long game is law. And I think that shows that like Ukraine is not willing to give up on international law, which is supposed to be creating a level playing field, for countries big or small, and where it can enforce its obligations against an aggressor state, it's willing to do so. So if you look at the outcome in this case, frankly, it was narrower than I think many of us were expecting. Russia's case, for example, under the Terrorism Financing Convention, very much hinged on the notion that you cannot provide funds to groups that are committing terrorist acts. And funds is defined under the convention as any asset. So Ukraine's argument was, well, weapons are any asset, and since they're basically fungible with money, because we can either give you money and you can buy weapons, or we can just give you weapons directly, that the Russians' supply of weapons to the Ukrainians should have fallen under the convention. And the case got a lot narrower because the court, narrowly divided, decided that in this particular context, they didn't think that weapons constituted funds under the convention. So I don't agree with that for many reasons, and they found kind of a very narrow legalistic path to kind of narrow the case. But at the end of the day, what you got was a ruling that, since the founding of the ICJ in 1945, the World Court has never found Russia to be in violation of international law, and now it has. And I think that raises a host of questions related to accountability and justice more broadly. What role should Russians play in UN institutions if the UN World Court has found that they violate international law? So I think that there's a whole host of consequences that may come from a court finding that Russia has violated its international law obligations, even if it is perhaps not the entire case that Ukraine brought forward. And I guess I would just make one more point, which is that, interestingly, from a legal perspective, as part of the CERT and terrorism financing case, the court also found a violation of provisional measures. And I think that precedent, that was independent of the violations of the underlying treaties. And I think that precedent is actually going to feed into now the merits case and the allegations of genocide case as it moves forward, given the blatant violation of provisional measures there.
I think maybe implicit in what you've said is that there's many different paths for bringing about accountability in international law through different international institutions, and we shouldn't necessarily just look to the ICJ as the place to do that. It can be the European Convention on Human Rights. It can be things like what you were indicating, the difficulty of participating in some of these institutional structures that Russia would like to participate in. Maybe one should note that the Russian candidate to serve on the International Court of Justice was not reelected this past fall. So now, for the first time in history since the Second World War, there's no Russian judge or Soviet judge on the ICJ. So there are these consequences that can unfold. Yuri, back to you. Again, this is sort of on the broader legal tactics approach, but I suppose I'm asking you to project into the future a bit. In May of 2023, the Council of Europe established and the UN General Assembly endorsed what it called a register of damage caused by the aggression of the Russian Federation against Ukraine. Meanwhile, as was discussed earlier with the ambassador, there are more than $300 billion worth of Russian assets outside of Russia in states that are largely sympathetic to the idea of reparations for Ukraine. So my question is, in your view, what might a claims commission process for addressing Ukraine's loss, damage, or injury as a result of Russia's invasion, what might that process look like? And I ask that in part knowing that typically the claims commission process has been built on the consent of all the states involved, and there's unlikely to be consent here, or based on a Security Council resolution, like with the UN Compensation Commission for Iraq. Again, unlikely to have that given the possibility of a Russian veto. So what might we be thinking about and looking at in a claims process?
Well, Sean, the short answer is no one knows.
You know.
There are many ideas and many theories on how these issues can be resolved, but there are three major problems here to put this into light. The issue of consent, the issue of immunity, and the issue of liability. Generally, if we look at the history of public international law, we will see that there were many claims commissions that were established after revolutions or wars. As all of those commissions did a fabulous work in dealing with the claims with respect to damages incurred as a result of armed activities. But all of those commissions were either by agreement between the two parties. Maybe that's also one of the elements of the agreement, Ambassador Taylor, that could be discussed when Ukraine obtains a strong position on the battlefield. In other circumstances, these commissions were established by the UN Security Council, like the United Nations Compensation Commission in the aftermath of Iraq's invasion of Kuwait. But again, here we have Russia's objection, so this is not an option. One of the options is to enter into an international treaty among all states who are sympathetic to the cause of ensuring that Russia pays reparation. And there are, of course, different ways how we can conceptualize this approach. One way is simply to rely on the UN General Assembly resolution, which already recognized the Russian war as the war of aggression, which has already indicated that Russia is responsible under international law. And essentially that could form the basis of a future agreement that will establish a compensation mechanism. It will be a very novel step. Nothing like this happened before, but at least in the absence of any opportunity of obtaining Russia's consent to this, right? This is still a good option, especially considering that the UN General Assembly was acting in the context of its United for Peace powers, which provide additional legitimacy to all these findings of liability. Another option is to look, for example, at the Vienna Convention on the Law Treaties, Article 75, which says that an aggressor state may not invoke a rule of consent to be bound by a treaty, right? Cannot invoke that as a defense in order to avoid obligations that may be imposed on that state as a result of a treaty that is adopted within the framework of the United Nations system, meaning it's either the decision of the Security Council or the action by the General Assembly within the framework of the United for Peace resolution. And here we have this resolution. So again, it could serve as the basis for conclusion of this treaty, and then Russia would not be in a position, legal position, to object to the obligations imposed on it by this treaty by arguing that it did not consent to it. Ironically for Russia, if you look at the preparatory works of the Vienna Convention on the Law Treaties of this Article 75, the Russian delegation was the proponent of this provision. And essentially, Russia was attempting to use this provision in order to justify agreements on reparation that could be imposed on an aggressor state. So, and Russia was also going back to the historical precedent when the Allied powers concluded a Potsdam Agreement, in which they imposed obligations on Germany to make reparations for all the damages caused by Germany during the war. So essentially, this would be a very powerful legal basis for states to act as well. But again, the question here whether states would be willing to set a precedent by acting on the basis of Article 75. I think that right now we can clearly see a consensus building around the idea to use the UN General Assembly resolution in which Russia was recognized as an aggressor, and then subsequent resolution calling for establishing the registry of damages in order to establish this legal foundation for the compensation mechanism. Then we also have another issue, the issue of immunity. Which assets you can take and how you can take them, right? So right now, the registry of damages, which is a separate system, right? It's a first step. Registry of damages that has been established only deals with the collection of evidence. And then this evidence, cataloging all the damages, will be presented to the Compensation Commission, and then the Compensation Commission will deal with the legal analysis whether these pieces of evidence satisfy requisite requirements of proof to establish claimed damages, right? So, but then there is a question of where you will get money to make reparations. And now we're getting back again to you, Ambassador Taylor, who suggested that, and I completely agree with you, we should take all those 300 billions of Russian assets. But even that would not be enough. But the question, I agree with that from the point of view of policy decision. Lawyers are not so fast in that. Why? Because there are serious concerns that if you, with respect to the basis of seizing those assets, one basis could potentially be countermeasures. But again, here we have to address the question of reversibility and the question of temporariness. The reversibility issue does not arise here because financial damages are not irreversible. The ICJ ruled it in several cases, and commentators agree on that as well. But the question of the requirement of temporariness, if you take the assets, this is the complete act, right? So you deprive Russia of its property to those assets. So this requirement of countermeasures potentially may not be satisfied unless you, for example, condition the use of these frozen assets as an element, use it as an element of inducement for Russia to make reparations. In other words, we will not give you these money. They're here, they're safe, but we will not give them to you unless and until you make reparations. There are other variations where you can satisfy this requirement, but it's one of them. So states are proceeding very carefully because the law is not entirely clear. Then another option is maybe adopting legislative or executive actions that through which states could essentially create a new exception to immunity. So we know that International Court of Justice in one of Germany versus Italy clearly made it clear that even though a state committed heinous crimes, in that situation the conduct of the state was Germany decimating an Italian village. So even though there are heinous war crimes, state conduct, that state conduct still enjoys immunity, right? Under the current system of international law. So states could potentially adopt laws or regulations in order to introduce these exceptions, which will then untie their hands to take the Russian assets. But again, it requires a political will, and it also requires some economic considerations. So that's the most important thing is that the world is moving right now in the right direction by actively brainstorming how these, how we can work within the current limitations of international law in order to ensure that reparations will be made to Ukraine. And then the ultimate issue is also liability. Who will determine liability, right? in the context of earlier claims commissions, liability was essentially established by commissions that had jurisdiction to rule on the matters of the use of force, or by the Security Council, which decided that Iraq was responsible for all that war. In our case, again, we don't have anything but the UN General Assembly resolution, which was adopted in that process. So again, even though this is a limited aspect, right? But at least it provides a new, at least a hook on which this element of liability can be addressed, so that the Compensation Commission could proceed with assessing the damages caused by the Russian aggression. Ultimately, it will take some time, but I would like to emphasize that given what we have already, we as an international community, what we have already achieved in the course of the past 2 years. Now we have this registry of damages. We're actively discussing the issues of compensation commission. We are moving at the light speed in terms of if we look at generally how international work is moving. So there is an optimism here that the accountability will be assured.
Great, thanks. Well, let's shift over to you, Ena, because we want to talk a little bit about post-conflict scenarios for justice and accountability. And I'm interested, given the work you've been doing, what are some of the ways that Ukraine's own security and justice institutions are adapting to or could prepare for the challenges of a post-conflict recovery?
Sure, yeah. And I think this is a really important question. If we think about that post-conflict period and how Ukraine is going to be able to thrive in that post-war period, the ability of these institutions to recover from the war and then to restore that sense of justice and that sense of security among the public and among eventually, we hope, the return of all of these people who have left Ukraine during the war, that's going to be vital. At the same time, it's hard to exaggerate the strain that this war has put on those kinds of institutions and the strain that war-related impacts are going to continue to have on those institutions, even when the conflict ends or the active fighting ends. And I'll just highlight 3 of those to give you an idea of that. So the first is addressing war crimes via the domestic legal system, or the role that the domestic legal system is playing in that currently. So currently, particularly for individual and lower level cases, Ukraine's domestic legal system is addressing those. This is something the government has encouraged, I think quite admirably, and it's been made possible by a big push to train prosecutors, so regular domestic prosecutors, in the handling of these kinds of cases, to train law enforcement in how to investigate, document, and handle evidence in these kinds of cases, and even to bring in civil society organizations in the documentation and evidence gathering process. And that's been, like I said, quite impressive how quickly they've been able to react to that. But the volume of cases is huge. I think as of last fall, it was about 110 cases, and those are reported cases. We expect there to be a lot more as the work continues, and also, just because I think a good proportion of them have yet to be reported. The other issue here is that when we look at comparable contexts, these kinds of cases are very slow moving, very resource intensive. So in Ukraine, as of maybe early summer last year, only about 100 of these cases have been examined, and of those, only 30 decisions have been issued. So what this says is that this is, and again, this holds true in comparable contexts, that processing these cases is going to take at minimum decades. And this is placing an enormous strain on a legal system that was already overloaded and that will have to deal with all of the other kinds of everyday legal issues that they'll be facing. There is a lot of conversation about what could be done about this, and some of the things that are being considered, and I'm sure you're all aware of this first one, is whether an either international or internationalized hybrid kind of tribunal could take on some responsibility for processing these cases. There are a number of hurdles to that that I won't get into, but we're not there yet. The other is increasing specialization and building capacity within Ukraine. Both possible, both good options, both a lot of international effort going towards these kinds of things. But even with both of those things, again, these kinds of cases are time consuming and resource intensive to process. And given what the Ukrainian people have been subjected to and the kinds of expectations that are being held in terms of receiving redress for grievances, or at least having them heard and receiving recognition for those kinds of grievances, I think one of the big challenges for the justice institutions and for the government is going to be how to manage these expectations. How to manage when people get to the point that they start to see that maybe they're not going to get the kind of response, either the speed or the outcome that they want from either domestic or international justice. Unfortunate as that is, that's unfortunately just the way these things often play out. A couple of the things that have been considered there is starting at this point to try and gradually communicate what some of those limitations are. It's not a message anyone wants to send, but in the longer term, what could be more destabilizing is to keep deferring that and then have that come as a surprise. Another option that I think is getting more and more consideration is considering non-judicial means. So considering things along the lines of memorialization, considering sort of dialogue-based, other means outside of the court system for these grievances to be heard and recognized, so that, at minimum, people's experience has been validated, even unfortunately in the absence of some kind of real redress. The second I'll highlight is just, as I mentioned, this court system going into the war already quite overstretched. During the war, what they've had to deal with is trying to pivot and find ways to provide justice to areas that were either temporarily or are still under Russian control, to try and give people who are in less accessible areas access, and then to deal with things like destruction of records, with cases that are much harder, and this is aside from war crimes cases, just everyday criminal cases, civil cases, where records have been destroyed, where evidence is inaccessible, where the distance between where it happened and where you're going to have to have that heard is going to be longer. And some of the kinds of things that are recommended there is pretty familiar things: increasing legal aid, making a big push to preserve records through rapid digitization and other means, and constructing temporary justice facilities along the front lines as those move back as quickly as possible, so that people who are in deoccupied territories will be able to have access to courts quickly. The final one I'll mention is to do with war-related criminality and disorder. There is, of course, the very obvious and drastic impact of the fighting on public security, but the war is already having and will continue to have a lot of secondary impacts. And a few of those I'll mention are likely to last again quite long term. The first is the increased circulation of small arms and light weapons, and this is something that we saw in the fallout of the conflict in Donbass before the full-scale invasion. But what we saw there as well, unfortunately, is it's very difficult to draw those back. Now that volume has increased, exponentially, and this is both weapons that the government distributed initially on the full-scale invasion to push back the Russians, but then also weapons that have been captured in the course of fighting. Already what is happening is that police are seeing these weapons make their way into use in crime, and it is having the effect of escalating the violence and severity of day-to-day crimes. So the dispute between neighbors, whereas previously that would be maybe easy to diffuse, you'll see a news story about someone who brought a grenade into that situation, someone who now has a gun where they wouldn't have before. So addressing that and doing effective, although this is difficult, DDR, disarmament in the wake of the conflict is going to be extremely important in terms of law enforcement's ability to control crime and the severity of crime. The second there that I'll mention has to do with the mental health and trauma impacts of the war. So this, and this is again something that's already apparent, this is having the follow-on effect of increases in drug use and alcohol abuse, leading again to a whole range of associated crimes. Now here, one of the big questions is how the legal system is going to address these kinds of crimes. You can see the clear line between war-related trauma, mental health, to the drugs and alcohol abuse, and to the kinds of crimes, property crimes or interpersonal crimes that come out of these kinds of things. And you can choose to treat this simply as criminal behavior, or you can recognize this as a public health problem. Pre-war and during the war, if you talk to law enforcement, if you talk to NGOs working on this, Ukraine has made some steps towards an integrated approach to this, which is more effective, but that's been very patchy. And at this point, the mental health system is really under strain. So the ability of the legal system to develop a coherent policy as to when and how these crimes should be, or these behaviors should be treated as criminal versus a health issue is going to be very important, as is better integrating and more consistently across the country, integrating that law enforcement response with mental health support. This is particularly important for veterans, where a lot of these issues, again, are already surfacing, unfortunately. And the second one, and I'll close this answer to the question with this, is domestic violence. This was a problem before the war. This has increased extremely rapidly, and it's only going to get worse. Complicating just, the fact of domestic violence is that law enforcement prior to the war was not very good at addressing these kinds of crimes. This was often seen as a private family matter. Now there's even more reluctance to involve law enforcement, or for law enforcement to involve themselves, because it is, again, often veterans who are experiencing mental health problems as a result of their involvement in the war, who are seen as heroes, and rightly so in a sense, but that then makes law enforcement reluctant to step in when these kinds of things happen. Fortunately, this is something that the government is very aware of. They have taken steps to try and address these. They've talked more openly about it. The national police are committed to trying to address their own internal issues with how law enforcement view these crimes. But I will say, and this, this applies beyond that to all of the kinds of things I've been talking about. One of the most worrying things is if you look at all of the recommendations for how to address these kinds of things, these are very costly. All of the plans that are being put together by organizations like our own, the recommendations that are being made, there hasn't been a comprehensive costing out. We don't know what the kinds of post-war aid commitments are going to be, but we do know that Ukraine's economy and Ukraine's government is going to struggle to fund the kinds of appropriate responses that will be necessary to strengthen the kinds of security and justice responses that will be necessary.
So we're just about out of time, but I think we might go another 10 minutes if that's okay with folks, just so we can get some questions out on the table. And I have one more question for Ena, but we'll take maybe 2 or 3 short questions from the audience in just a minute. And then I'll give all 3 panelists the opportunity to sort of sum up and react. Question for you, Ena, is reconciliation within Ukraine. You talked about the sort of de-occupied areas. There may come a time when there's a need to bring Ukrainians together. What's your work saying to you about that?
Sure, and I will try to be brief. This I think is also a very important issue. The war has either created or exacerbated existing fault lines in Ukraine, and this is something that, if you look at how Russia has tried to, not just in the full-scale invasion, but going back to 2014, even before, tried to undermine Ukraine, it's a hybrid conflict. They're likely to try and to continue to play on social divisions as a means to weaken the Ukrainian state. And yeah, some of these fault lines that the war has either worsened or created are pretty obvious. I think that there's a lot of questions around, or there's a lot of concern among civil society over the treatment of Russian-speaking populations. A some of the prejudices or assumptions around these populations who are sometimes this is sometimes intersecting with the concerns around the occupied territories. Some of the things there that are of concern are actually treatment by government, treatment by security services. There have been reports, or maybe the better way to put it is there's a lot of fear that Russian speaking populations are viewed by certain parts of the security services primarily as suspects rather than victims. And some of the kinds of things that are being put into place to address use of the Russian language, use of the Russian Orthodox Church, depending how delicately those are handled, how the messaging around them is conveyed, could either make those better or make those worse. For the occupied or deoccupied territories, one of the big fears that has been reported by civil society organizations working in or on that is again that these populations following the war will be viewed with suspicion. And there is, I should say, there is a security risk, right? It is a fact, I think, that even should Ukraine regain those territory, there will still be pro-Russian actors in those regions. That's, I think, a fact. But the ability to differentiate who those are and who are everyday people that have continued to live there, that's going to be difficult. And there has been, after 10 years or more of Russian occupation, a lot of misinformation that has taken what's a real fear and built this up in the minds of that population, so that their expectation among some of them, if Ukraine should take back that territory, is of things like mass arrests, maybe even violence, those kinds of things. I think what will be necessary to try and reintegrate those effectively is a lot of good preparation for security forces that are going in there, and to take an approach of working with populations, of engaging civil society organizations, and of having a security, of developing local security policies in concert with and in dialogue with local leadership there. And then, maybe to keep it a little bit shorter, I will say as well, there are populations, or there are divisions that are maybe less obvious. So we have heard concerns about divisions between parts of the country or populations that have been more or less directly impacted by the war. So resentment, say, of people who are living, relatively speaking, normally in Kyiv versus those more on the front lines. Resentment between people who joined the military and chose to fight versus those who didn't. And part of the reason this is of concern is because you will have, in the wake of the war, a population coming out of the military that is quite sizable, that has been fighting for years, that has, and you could say rightly so, high expectations for the kinds of support and service they will receive from the state following that. But it's not yet clear that the state is prepared to provide those successfully. And what I heard from some of the people the last time we were there is that expectation and that feeling, justifiably or not, of entitlement, if that is not met, that is explosive, or could prove to be explosive. And then I'll very quickly maybe finish by saying, I think one of the other things that's going to be very important to establishing and continuing to strengthen the trust in the Ukrainian state and institutions is making good on some of the pre-war reform processes that were paused during the fighting. If you think about, and this is something we heard over and over, if you think about the reasons that people are fighting this war, the reasons that they are willing to make the kinds of extreme sacrifices that they're willing to, it's to have a different kind of state. It's to be able to make that break with the past and the kind of Soviet model state, and have a state where it's genuinely ruled by law, where people can expect justice and fair treatment, where people feel secure, where and if that expectation is not met, We've seen Ukrainian people push back very hard against their government in the Euromaidan revolution and the revolution before that. And now, after having made that sacrifice for so many years, if those reforms are not seen to be advancing in terms of anti-corruption reforms, judicial integrity, and some of the law enforcement reforms, I think that as well could prove to be pretty destabilizing.
I think in a very short amount of time, you've served up a number of challenges that face Ukraine and the international community and helping Ukraine, and I think that's really been important. So we are pretty much out of time, but if there were 2 or 3 very short questions, and I'm serious, 30 seconds and no more, and I will cut you off, so I'll take these 3 questions here. Yeah, go ahead.
So the first question I'd like to put is, we see a lot of jurisprudence now coming out of the ICJ in the context of South Africa v. Israel, which is though slightly different a situation from the one between Ukraine and Russia. Do we see that jurisprudence influencing how the case between Ukraine and Russia will go forward?
Good.
And if I may just add another layer to that, could Ukraine also put up, if it hasn't already, a claim for violation of the right to self-determination?
Self-determination. Okay, Ron?
Quick question on war crimes. All the focus has been on ICC and Ukraine, but what about all the state parties of the Geneva Conventions who are obligated to prosecute or extradite? Why isn't there pressure to do that? 2 years ago, the U.S. enacted legislation allowing us to do that, but there's no indictments. Germany and Switzerland and Nordic countries have done it. On claims, there is a precedent, of course, for the Ukraine registry, and that's the UNRWA, the Palestinian registry, wall registry of damage. And that was set up because Israel wasn't going to pay compensation. And this is like that, and that's gone on for 15 years. It will take time. The Council of Europe resolution anticipates that it will take time, and eventually one will find a solution, maybe. It's premature to take that. Even the G7 statement that was issued said, don't vest assets. That would be unlawful.
We're going to do this. Go ahead, ask your question.
So there has been large damage on Ukrainian environmental and natural resources as a result of the Russian invasion of Ukraine. So my question is, are you expecting any separate legal actions in terms of the environmental and the natural resources damage, such as, for example, 2 interstate arbitrations have been brought by Azerbaijan against Armenia, arising from another invasion, the illegal military occupation of Azerbaijan by Armenia. So are you expecting any similar actions like that or any other one?
Great. Okay, so you don't have to answer all of those questions, but if you'd like to answer some of them or all of them or any closing statements, I'm going to start with Marney and then work our way down the panel.
Okay. I do think that it's helpful to think about this as kind of an international legal ecosystem where you can't necessarily do everything in one particular forum, but need to think about how the pieces kind of work together. So, I think the question about persecuting war crimes and the parties to the Geneva Conventions, I think about the precedent of the Netherlands has brought cases, for example, against the perpetrators of MH17 under their universal jurisdiction. So I think that there are complementary ways for different pieces of the international legal ecosystem to work together and kind of create a greater web of accountability that's maybe bigger than the sum of its parts. So I think I would maybe leave it at that. I think that there are some challenges, of course, to each of these individual pieces, but hopefully as there's varying path forwards on varying timelines, one thing is clear, which I think is that the broad swath of the international community is focused on accountability and justice, and hopefully Ukraine won't be alone as they're pushing that agenda.
My suspicion is that Marney is thinking about many of these ecosystem possibilities with our client and prefers not to get too much into the details of it. Yuri, your thoughts?
My thoughts is that I agree with you completely. That G7 said what it said, which underscores the problems that we are dealing with. But it doesn't mean that G7 is not thinking creatively how to move forward. And I know I'm working right now with one of the G7 member state, and I know that there are very intense discussions on how to deal with these matters. So we will see some progress down the line. The precedent you mentioned is very helpful, but then that compensation fund is about to be funded by some other states, willing states, as far as I understand. And it's not for compensation to be paid to Palestine, right? It's only to collect all evidence. That's what the Registry of Evidence is doing, and yes, it follows that precedent, but the Registry of Damages does not pay compensation.
That's right.
It only collects evidence, and then the next step is the compensation commission. Why some states do not take actions? This is the question to those states, of course, because there are many political and geopolitical considerations why they may prosecute, while they may not prosecute. A good example is the Netherlands. It did institute criminal proceedings and apparently achieved more than we did before the ICJ, right? Because people are held to criminal liability, whereas the ICJ said that, well, look, I cannot deal with the question of Russia's responsibility for shooting down MH17 because that's not within my jurisdiction, right? So Russia escaped that completely. But to ensure that Russia cannot escape even those limited elements of jurisdiction that we have out there, we always have to be very careful how we articulate our claim, how any state seeking justice articulates claims, how those claims are litigated, how those claims are being viewed in the larger geopolitical moves and context. And for example, getting back to your question with respect to what signals we have seen. No signal important for Ukraine, because Ukraine will not be dealing with those issues since the ICJ made clear that it will not be dealing with Russia's liability. But that judgment is very helpful to other genocide cases. I'm right now representing the Gambia against Myanmar, and there are some interesting points there that you can discern for your legal strategy with respect to how to litigate your genocide case, as opposed to make a difference from the one where Israel is likely to escape unscathed, right? Most maybe it will be incitement to genocide, but not the commission of genocide. So you do have to look at all those, and not just the judgment itself, but also the separate and declarations, separate opinions, dissenting opinions. They provide a wealth of knowledge for you. Like, for example, the dissent of Abrams. Just read it in the case between Russia and Ukraine on the genocide case, and it will indicate to you how the court, or at least some members of the court, because Abrams was the intellectual force behind the judgment that we have, how at least some members of the court view the case that was brought by Ukraine. So you have to carefully examine, carefully analyze, and make sure that it's not like you pushing all red buttons that can be pushed, or bringing all claims that can be brought. Just do it very carefully, very thoughtfully, because otherwise it can come back and bite you hard.
Ena, final thoughts from you?
Maybe I'll just finish by saying I know that domestic prosecution of war crimes is not Ukraine's preferred option. I think that they have and are still trying to have those dealt with by some kind of, at minimum, internationalized tribunal. So far that has not been successful. But one of the things that they're trying to do in the training and the capacity building is make sure that the foundation is there such that if at some time that could be possible, that the evidence would be collected and documented and prepared in such a way that that wouldn't preclude that kind of thing. And that may be one reason that I think so far prosecutions have focused mostly on very low-level individual perpetrators who would probably not be dealt with by any kind of international tribunal regardless. And then I'll just say, I don't know about legal claims around natural resources, but I do know that that is one of the points that's covered in, if you look at the 10 points that Ukraine put out, just kind of a foundation for what they would consider in terms of peace negotiations, that's definitely addressed there.
Well, I'm sorry to hold everybody, but I think it's been a very rich discussion, and can we just do two things before we break? First of all, Vita did a huge amount of work to organize this event, so how about a round of applause? And thing number two is if you do have follow-on questions, I'm sure the panelists would be happy to stay for a little while and chat with you about it, but please give a round of applause for our panelists.
Or, wasn't permitted to be covered under the rules, wasn't evidence, but now you have a lot.
Oh, thank you, Rosie, yeah.
And it was so nice to hear you in this other capacity.
You got squeezed just because we started late. And,